ask is that we take a roll call of the members of the committee. Joe?
Yes, Your Honor. Judge Avery Whetstone. Judge Bellis.
Here.
Judge Cobb.
Here.
Judge Farley.
Here.
Judge Hernandez.
Present.
Judge Gwen O'Dowd.
Here.
Judge Pratt is not available. Judge Trulia. That's it, Your Honor.
Thank you very much. We have circulated and posted the items that are before the Rules Committee for this public hearing. The purpose of this, obviously, is to receive comments from members of the public who are interested in some of the proposed rules changes. The rules changes that have been preliminarily approved by the Rules Committee are after this public hearing will be considered by the judges of the Superior Court in their annual meeting. I forget, Joe, do you remember the date?
Yes, June 10th. I'm sorry, one second. June 11th, Your Honor.
June 11th, and that also will be done, I believe, virtually, and
Yes.
will be available to members of the public to watch that proceeding as well. As far as I know, we have 7 people who have signed up to testify before the committee, and it looks like they are all testifying on the same rule, 8.4, the changes to that rule of professional conduct. Each participant will have 3 minutes to address the committee. I will keep time, and I will notify you when you have 1 minute remaining, if you can see me, so that you'll be able to pace yourself. And at the end of the 3 minutes, I would just appreciate it if you would make some brief conclusory comments, and then we will move on.
Excuse
Is
me,
there
Your
anything
Honor.
else, Joe, before we begin?
Yes, I'm sorry. Yes, I believe the notice went out was 5 minutes. In case anybody needs that.
I appreciate the correction. 5 minutes. Thank you. Anything else before we begin, Joe?
No, sir.
Okay. The first person who has signed up is Attorney Megan Wade. Attorney Wade?
Good morning. Chairperson Justice McDonald and respected members of the Rules Committee of the Superior Court. My name is Attorney Megan Wade, and I am an appellate attorney at Sexton and Company in Hartford, Connecticut. I appear before you today to speak in support of the adoption of proposed amended Rule of Professional Conduct 8.47. It was about 11 months ago when I first appeared before this committee about amending the rule with an eye toward eliminating bias and discrimination occurring within the legal profession in Connecticut. What has transpired since last year's public hearing has been nothing short of tremendous. After approaching the Connecticut Bar Association with this proposed amendment, my colleague Anya Goldsby and I were met with immediate support to craft language specific to Connecticut's rules of professional conduct. The CBA formed a working group to tackle this monumental task, and in the time since I spoke with you last year, we met countless times. My colleagues in the CBA, some of whom you will hear from today, volunteered a lot of time, effort, and passion to this amended rule change, with Attorney Cecil Thomas spearheading the charge. I do feel compelled today to comment on the extensive deliberative process that gave rise to this proposed rule change. Over the course of several months, we compiled a 50-state survey to see how other states have amended their rules following the American Bar Association's adoption of Rule 8.4G back in 2016. We drafted, redrafted, redlined, and debated every word that now appears before you. We also created a survey to circulate to members of the Connecticut Bar to compile data regarding the frequency and types of discrimination and harassment our colleagues have faced and continue to face within Connecticut. That survey demonstrated pervasive discrimination and harassment within the Connecticut Bar and confirmed the need for this proposed rule change. We also then went on to speak with numerous sections and committees within the CBA as well as individual CBA members and the CBA House of Delegates. After many months of thoughtful and thorough deliberation and with the support of the CBA, Attorney Thomas substituted the CBA's proposed language in place of my original proposal presented to you last year. The CBA proposal is the culmination of months of thoughtful consideration and discussion. At this point, the reason for this rule change are numerous. Particularly compelling are the results of the survey circulated to members of the Connecticut Bar. Harassment and discrimination are prevalent in Connecticut, and we can do better to hold ourselves as a profession to a higher ethical standard. I believe that proposed Rule 8.47 is a step toward effectuating systemic change in eliminating all forms of harassment and discrimination currently faced by attorneys in Connecticut. I want to conclude today by thanking members of this committee for encouraging me last year to reach out to the CBA to work on drafting a proposal. I also want to thank my astounding colleagues on the Rule 8.47 working group, many of whom I have never met in person due to the pandemic, and of course, Attorney Cecil Thomas, who guided us all through this process and advocated on behalf of the CBA for the adoption of Rule 8.47. Thank you for your time.
Thank you. Next is Attorney Anya Goldsby.
Good morning. Thank you, Chairperson McDonald and members of the Rules Committee. Today, I am speaking in support of the proposed amended Rule 8.47 regarding discrimination and harassment in the practice of law. So as Co-Diversity Director of the Young Lawyers Section, former president of the George W. Crawford Black Bar Association, and as a Black woman in a profession where less than 2% of lawyers look like me, I have suffered my fair share of discrimination and harassment, both as a law student and as a lawyer in the state of Connecticut. Imagine George Floyd was murdered last year in 2020. Now imagine just a few days later, reading something on the internet that was personally hurtful to you. Now imagine a current white male lawyer telling you as a Black woman that you are suffering from Black entitlement and you are a race panderer, and then also calling you a race pandering nitwit, amongst other things. This was not the first time that I've been subject to such level of bias and discrimination due to my protected class as a Black woman, but this was the first time that I have been subject to this so blatantly and so publicly. Thankfully, I had allies in my corner, such as Attorney Megan Wade and other members of the Connecticut Bar Association who saw what I saw. This conduct was never and should never be okay. All forms of discrimination and harassment do not have any place in the practice of law in Connecticut. As lawyers, we are a self-regulating profession, and our rules of professional conduct are meant to assist in that regulation. This proposed amended Rule 8.47 is meant to protect discrimination and harassment within the practice of law and not to limit it just to representing a client, because lawyers, as we know, our roles go far beyond that. I want to personally thank Attorney Megan Wade for working with me and bringing this original proposal before the Rules Committee. And I also want to thank Attorney Cecil Thomas and other members of the CBA task force for your hard work on getting it this far. Know that I personally appreciate you being by my side during this process, and I am so thankful and grateful for your time. Thank you for your consideration.
Thank you, Attorney Goldsby. Next is Paul, I hope I pronounced this correctly, Michalski. Is that correct?
Close enough. Well, distinguished members of the Rules Committee, my name is Paul Michalski. Thank you for allowing me to comment today on proposed Rule 8.47. I would like to focus on three ways of approaching the proposed rule. Can we adopt it? Should we adopt it? And must we adopt it? Other jurisdictions have considered similar rules based on ABA Model Rule 8.4G and have answered the should we question, I believe, wisely with a resounding no. We should not adopt a rule that targets lawyers' speech and is dangerously vague. In one jurisdiction where a similar rule has been adopted, a federal court already answered the can we question, I believe correctly, with a resounding no. Under our Constitution, we cannot adopt a rule that targets lawyers' speech and is dangerously vague. The CBA says it has tweaked the language in a way that they hope gets over the can we hurdle. Maybe 8.47 would survive a challenge and maybe it wouldn't, but in your proceedings you made clear it wasn't your job to consider the constitutionality of the proposed rule, the can we question. That leaves must we and should we. CBA has also tried to convince you that the proposed rule is a must-we issue. In your proceedings, they raised the specter of a diversity, equity, inclusion crisis in our state and argued that the current Rule 8.44 is inadequate to address that crisis. The CBA certainly did not make a convincing must-we case. The Office of Chief Disciplinary Counsel and the Statewide Grievance Committee each suggested that this was not a must-we rule. In fact, they implicitly questioned whether it even passed the lower should-we test, noting that existing rules, including 8.44, are, quote, applied robustly before reviewing committees in the Superior Court to limit and deter the conduct described by the proposal in its commentary. The Grievance Committee also raised several concerns about the clarity and scope of the proposed rules, concerns which were simply dismissed by the CBA without any modifications to the proposal. I suspect other interested parties faced a slightly different must-we question. Must we come out and publicly endorse proposed Rule 8.47? In our current virtue signaling and cancel culture, I wouldn't be surprised if some, if not many, of the attorneys and law firms voting in favor of the rule in CBA committees and signing their names on letters in favor of the proposed rules did so not because they concluded the proposed rule passed the should-we test, but because they feared the consequences to their reputations and businesses of not endorsing a rule portrayed by the CBA as necessary to address a diversity, equity, inclusion crisis. After all, a refusal to endorse the proposed rule could be used to label firms as against diversity, against equity, and against inclusion. That leaves no room for an honest should-we analysis. I wonder what the outcome would have been of an anonymous poll of CBA membership. That leaves only the should-we question. Nearly every other gatekeeper, 14 out of 18, facing the question you face today, has concluded that a rule like 8.47 fails either the can-we test or the should-we test. Those opposed to the proposed rule are not against diversity, not against equity, and not against inclusion. They are against a rule that by its very nature has a chilling effect on and can be used to silence speech that is out of favor. They are against a rule that can be coercive even by its mere existence, even by its mere proposal. They are against a vague and overly broad rule that can be used to regulate more than the administration of justice. I thank the committee for its careful consideration of this rule thus far. I respectfully urge you to vote against this rule because whether or not it might pass the can-we test, it does not pass the should-we test. In doing so, you will not be voting against diversity or against equity or against inclusion. You will be affirming the importance of existing Rule 8.44 and can do so explicitly. You will be affirming the importance of freedom of speech. You will be affirming the judgment of the Office of the Chief Disciplinary Counsel and the Statewide Grievance Committee. And you will be doing your job as the final line of defense against culturally popular rules that, while motivated by the best of intentions, go beyond ensuring the integrity of the practice in law and may even risk undermining that integrity. Thank you very much.
Thank you, and I apologize for mispronouncing your name.
That's quite all right. My mother says it wrong.
Thank you. Next is Cecil Thomas.
Good morning, Justice McDonald and members of the Rules Committee. It is my honor to address you in support of proposed amended Rule 8.47. I will take just a few minutes to review some of the history that brought us to this moment. As you all know, approximately a year ago, on June 5th, this august body was presented with ABA Model Rule 8.4G. And after discussion, referred or decided to table that proposal to the September meeting in 2020 to allow the proponents of that rule, including Attorney Wade and Attorney Goldsby, who have spoken before me today, to coordinate with the Connecticut Bar Association to submit additional materials to the committee for review. Thereafter, on June 15th, Attorneys Goldsby, Wade, and Attorney Stovall from the Standing Committee on Professional Ethics of the CBA addressed the House of Delegates regarding this proposed rule, and an 8.47 working group was formed within the Connecticut Bar Association to address the potential for this rule. Throughout the month of June and July, the working group met countless times to develop a proposed rule. We're very cognizant of the concerns that have been presented in response to ABA Model Rule 8.4G, specifically concerns about overbreadth and First Amendment concerns. And certainly those concerns were taken very seriously in the development of the rule that is before you. Oftentimes there is a conflation of the different rules to make it seem as if all of them are the same. And in many ways, the CBA proposed rule that is the one that has been approved preliminarily by the Rules Committee is significantly different from the ABA Model Rule, specifically to address those concerns about overbreadth and concerns under the First Amendment. Throughout the months of July and August, the proposed rule was presented to 11 different committees and sections. It was approved by the Diversity, Equity, Inclusion Committee, Standing Committee on Professional Ethics unanimously. It was approved by the Young Lawyers section, the Human Rights and Responsibilities section, the LGBT section, the Women in the Law section, the Veterans and Military Affairs section, the Professionalism Committee, before being presented to the Legislative and Policy Review Committee. Thereafter, it was also presented and approved by the Professional Discipline section and the Litigation section, as well as the Labor and Employment Law section, before coming to the LPRC and then the Executive Committee, and then being presented to the CBA House of Delegates in early September in a special meeting. CBA House of Delegates voted 39 in favor, 11 opposed, and 1 abstention. And so this is a very carefully considered rule and not, contrary to other comments that have been submitted, the product of cancel culture or virtue signaling. It was rather the product of an extensive deliberative process within the CBA. Thereafter, this rule was presented to a number of organizations and entities outside of the Connecticut Bar Association. It has been supported by the Connecticut Attorney General's Office, the 4 affinity bar associations within Connecticut, the Connecticut Asian Pacific American Bar Association, Connecticut Hispanic Bar Associations, the George W. Crawford Black Bar Association, and the South Asian Bar Association of Connecticut. The deans of 4 of the Connecticut area law schools, Quinnipiac, University of Connecticut, Western New England, and Yale, have also submitted comments in support, as well as the leaders of 28 major law firms, legal aid organizations, government and corporate legal departments, which have signed on and expressed support for this rule, as well as the Lawyers Collaborative for Diversity. Again, this is the product of careful study and consideration. The Rules Committee has before it the results of the CBA survey, which was conducted in September of last year. It also has comments that summarize other studies of the profession that reveal, for example, a 2020 study that revealed that 75% of women lawyers respondents had direct experiences with sexual harassment or misconduct, with 73% of those respondents describing those experiences as occurring often or frequently. An ABA study that took place also in 2020 said that 40% of lawyers who identify or found that 40% of lawyers having disabilities or as LGBTQ+ reported experiencing discrimination, harassment, and bias in the workplace. The CBA survey revealed very similar and troubling statistics. More than half of the respondents during our brief survey period reported that they had experienced discrimination, harassment, or sexual harassment based on membership in a protected class and conduct related to the practice of law. 44% of the respondents reported that they had witnessed discrimination, harassment, or sexual harassment based on membership in a protected class in conduct related to the practice of law. Again, what's troubling is that the majority of those reported experiences experienced or took place within the workplace context. Client
Attorney
representation.
Thomas,
yes.
Attorney Thomas, I'm not certain if you can see me, but your 5 minutes has expired. If you'd like to give a conclusion sentence, I'd appreciate it.
I certainly will. Thank you, Your Honor. To summarize, again, this was a carefully crafted rule, one that took into consideration those concerns that have been raised. They are expressed in the language that has been developed, and I urge this committee to approve the proposed amended rule.
Thank you very much. And by the way, anybody who has commented, if you want to submit written materials, that's fine as well, but we're keeping this to 5 minutes for this public hearing. Next, and I cannot see him, I don't know if he's here, is Attorney Mario Sarami? There he is.
Hi, Your Honor. Can you see me now?
I can.
Or maybe you can't see me. Can you see anyone?
I can see you, so please proceed.
Very well. May it please the members of the committee, I oppose the rule. I am the last member of the First Amendment Lawyers Association in Connecticut. The other member, Dan Silver, passed away about a year ago. You should have him here, but you're stuck with me. The First Amendment Lawyers Association is a national organization. It is basically a trade guild of First Amendment attorneys across the United States. The goal of this rule is good. The means is illegal, and it's a bad idea. Lots of illegal laws or rules are carefully crafted and well-intended. Attorney Thomas said that this rule is meaningfully different from the rules struck down and rejected. I don't see it. I don't understand how. I understand that, and I haven't seen his email, that Professor Eugene Volokh, as I understand it, sent an email to the committee. I saw it in the agenda. I have not seen that email. Professor Volokh is probably the single most well-known and respected First Amendment scholar in our lifetime. He and I do not always agree. He is a friend of mine, but we do not always agree. He is probably the smartest guy I know. He is like a Judge Sheldon if Judge Sheldon was a UCLA First Amendment law professor. You should take his analysis, whatever it is, very seriously. I sent a letter to the committee on November 13th, briefly explaining the laws in Connecticut and the rule, giving a big analysis, about 5 pages long. I was clearly unpersuasive. I was unable to persuade the committee. If I can't convince your honors with my letter, and if my colleague Zach Greenberg, who brought the case in Pennsylvania, the Greenberg versus Haggerty case, which struck down the same rule, if that federal judge's 40-page opinion cannot convince your honors that you shouldn't adopt this rule on First Amendment grounds, I don't think I'm going to today. So I want to talk about policy and enforcement concerns instead. There is a big problem with access to justice in Connecticut and in our country generally, and how lawyers speak to their clients has nothing to do with it. This rule will actually harm that interest. Every criminal defense attorney worth the title has been illegitimately grieved multiple times. Now you're indicating you're providing a situation where it is legit to grieve someone for demeaning language. That's the language in the commentary to the rule. That's what this rule is making wrong, is demeaning language. What kind of effect is that going to have on the grievance committees in our state when they're determining probable cause? What kind of effect is that going to have on disciplinary counsel? What kind of questions are going to be asked? Demeaning language? What kind of effect is that going to have on the types of clients people choose to take or choose not to take, the kinds of people who might bring an illegitimate grievance on that ground? I want to bring up a scenario there. I had a case before Judge Prats, before all this COVID happened. I was representing a young man, the son of a friend of mine. This young man was a person of color. He was accused of selling $20 of crack cocaine. Judge Prats gave him a very hard time from the bench. We applied for a program. The program happened to be granted. What she did not see, what no one could see, was the conversation that I had with this young man, with his father present, about the effect and about how young people of color are judged and how the system treats them unfairly in our country. There was some demeaning language that was used in that conversation. It was a very serious conversation in order to try to save this young man's life, to get him back on the right course. That kind of discussion needed to happen, and it would be chilled by this rule. His father used much more demeaning language than I did, but that conversation should not have occurred under this rule. That is what a chilling effect is. Most people do not go to the limits of permissible speech. Most people stop way short of it. So in terms of what this rule's effect is going to have, it's going to affect how people talk with their clients. It's going to inhibit the kinds of advice, the kinds of candid advice they give about how the systemic racism that young people face, in people of color face, and minorities face in our justice system. One last piece. I know that it is often pointed out that the text says that this rule does not preclude legitimate advice or advocacy. The thing is, you don't know whether something is legitimate until it's been litigated, and most people will just stay away from that, won't they? It will affect how they choose their clients, how they speak to their clients, the kinds of advice they give. Again, I may not be able to persuade your honors on the First Amendment grounds, but I hope you take seriously the policy concerns and enforcement concerns I have raised. Thank you, your honors.
Thank you very much, Attorney Sarami. Next is Kim Colby.
Justice McDonald and honorable members of the committee, my name is Kim Colby. I'm director of the Center for Law and Religious Freedom of the Christian Legal Society, and I want to address my remarks as to why proposed Rule 8.47 should not be adopted to the legal decisions that have come down. There have been 4 since the ABA adopted 8.4G in 2016. These decisions all indicate that rules like proposed Rule 8.47 are unconstitutional because as many of the speakers have already noted, they chill attorneys' speech in a way that violates the free speech clause of the First Amendment. So the first decision came down in 2018, 2 years after the ABA adopted 8.4G. And that decision is called National Institute of Family and Life Advocates, or NIFLA, versus Becerra. In NIFLA, the Supreme Court of the United States held that government restrictions on professional speech, including lawyers' professional speech, are generally subject to strict scrutiny because they are content-based speech restrictions and therefore presumptively unconstitutional. The court rejected the basic operating assumption underlying ABA Model Rule 8.4G and proposed Rule 8.47 that professional speech is less protected by the First Amendment than other speech. And instead, the court reiterated that strict scrutiny should be applied to content-based laws that regulate the non-commercial speech of lawyers. The second set of cases, there are two from the Supreme Court. In 2017 in Mittal v. Tam, and in 2019 in Iancu versus Brunetti. Both of these decisions, the court reaffirmed that any viewpoint discrimination in the treatment of speech by the state is presumptively unconstitutional. And unfortunately, this rule would allow the state officials to engage in viewpoint discrimination in deciding which of the attorney's speech violates the rule, as the previous speaker was indicating. So in Mittal, Justice Alito, for the plurality, explained that government officials' determination that some words do or do not disparage, and that's the word they use, disparage a person, offends a bedrock First Amendment principle. Speech may not be banned on the ground that it expresses ideas that offend. The court continued, speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful. But the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. Similarly, Justice Kennedy, in his concurrence that was joined by Justices Ginsburg, Sotomayor, and Kagan, also warned that it's more important that we put our reliance on substantial safeguards of free and open discussion in democratic society, rather than allowing government officials to decide which speech disparages, which speech demeans, which speech is okay. The ABA's formal opinion 493 that it issued last summer in an attempt to save 8.4G does not even deal with these three Supreme Court decisions, and therefore it is of no use in upholding rules like proposed Rule 8.47. And the letter from Professor Blackman and Eugene Volokh, which has been referred to already, that the committee received, outlines why formal opinion 493 is not of any help. I'd like to just briefly touch on the Greenberg versus Hagerty decision, in which the United States District Court for the Eastern District of Pennsylvania held that Pennsylvania's newly adopted Rule 8.4G was facially unconstitutional because it chills attorneys' speech. The court relied on the Supreme Court's decisions in NIFLA and Mittal. And specifically, that court said, this rule will hang over Pennsylvania attorneys like the sword of Damocles. This language will continuously threaten the speaker to self-censor and constantly mind what the speaker says and how the speaker says it, or the full apparatus and resources of the Commonwealth may be engaged to come swooping in to conduct an investigation. Defendants dismiss these concerns with a paternal pat on the head, and then the court continues with the fact that this threat of being disciplined for what we say is unconstitutional and it chills attorney speech. I thank the committee for its time.
Thank you very much. Next is Stephen Lyon.
Good morning, Justice O'Donnell. Justice McDonald, honored members of the committee. My name is Stephen Lyon. I'm submitting this comment in opposition to proposed Rule 8.47 of the Rules of Professional Conduct. I would like to begin by emphasizing I appreciate the work of the committees and individuals who worked on drafting this proposal, and I'm making no accusations of nefarious motives in this proposal, as I'm sympathetic to the goals that are being pursued. But I believe that the proposal as drafted will run counter to those goals in the long run, and in the meantime will result in other important principles and rights being overlooked and possibly even being violated. The first issue that this proposal has is that the wording is vague, leaves too much interpretation, and is at times nonsensical. Beginning with the second sentence of the black letter portion, the proposed rule states, quote, "This paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from representation or to provide advice, assistance, or advocacy consistent with these rules." The sentence is redundant at best and nonsensical at worst. The clause, quote, "consistent with these rules," unquote, removes any meaning regarding the previous part of the sentence. Obviously, a lawyer can act in accordance with these rules. The only reason for having a sentence that begins, quote, "this paragraph does not limit," would be if what followed was an exception to that rule. If the goal is to allow lawyers to continue to follow the rules in other sections regarding the freedom to choose who they represent and the ways in which they will represent them, then those sections should be specifically mentioned and not just the vague term, "these rules." The issues regarding vagueness continue in the commentary as well. In the first and second paragraphs, the word "includes" is used before listing actions that could constitute harassment and/or discrimination. The problem with this is that the word "includes" does not mean "limited to." While I understand not wanting to create ways to avoid disciplinary action by technicality, this also creates no limit to what the presiding authority may consider to be harassment or discrimination. This creates a chilling effect and may damage our legal discourse. For example, the word "includes" makes the words "severe" or "pervasive" meaningless and may prevent lawyers from participating in debates, forums, and conferences for fear that stating an academic, moral, philosophic, or pragmatic opinion, which happens to be unpopular or even discriminatory, may result in misconduct charges. This, along with the fact that the commentary is non-binding on the arbiter. In fact, if there's a discrepancy between the black letter and the commentary, the arbiter is required to follow the black letter rule. It makes it impossible for practitioners to truly know what the standard is. I also object to the standard being adopted in the proposed rule. Changing the wording to a negligent standard through the words "or reasonably should know" is a difficult standard to follow and may result in the chilling of speech. The only section in the professional rules where such a standard is applied is in the trial setting regarding extrajudicial communication by an attorney during trial. In this example, the rule is narrow and involves someone who is trying a case who therefore would have a basis for knowing what communication is acceptable and has access to rules and historical rulings in that particular situation. In the kind of situations addressed by the proposed rule, the type of activity being regulated is so vast and can include so many things, it is nearly impossible for there to be a reasonably should know standard that can be enforced fairly and consistently. The proposed rule creates inconsistency within the rules of professional conduct as well. One example is Rule 1.16(b)(4), which states that a lawyer may withdraw from representation when the client insists upon taking action the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. It is very easy to see, based on the diverse cultural backgrounds and moral and religious beliefs of the members of the Connecticut Bar, how withdrawal in accordance with this rule might be construed as a violation of the proposed rule. There are several other areas where vagueness and overbreadth is an issue, but the biggest area is the clause related to the practice of law. Paragraph 5 of the commentary, which intends to define what this means, is unhelpful. First, it uses the word "includes" again, which has the same problem as earlier. Second, it is so broad that it's hard to find an area where there is freedom for debate or discussion, specifically with a clause and participating in bar association, business or professional activities or events in the connection with the practice of law. This would encompass CLE presentations, debates, publishing articles in legal journals, and classes taught by law schools. It would also encompass membership in racial affinity groups like the Black Bar Association, religious affinity groups like the Christian Legal Society, and political and philosophical groups like the Federal Society that regularly have discussions and presentations where viewpoints are expressed and may be considered harassing or discriminatory. I only have a couple seconds left. In general, I think it's important to also realize that this is not content neutral speech regulations. There are carve-outs specifically for speech that people like, and we specifically leave out speech we don't like. And it's important that for our legal discussion and for our state laws that we apply neutral rules and that we give freedom of speech a primary focus. Thank you.
Thank you. Attorney Del Campo, did anybody else sign up late to testify before the committee?
I believe, Your Honor, that I don't believe so, although if you give me 1 second, I will make certain.
Yes, we'll stand at ease for a moment.
We did have someone join the call a short while ago. I don't know if we have their information.
Right. 1 second.
Yeah, it looks like a Tracy M joined. I'm not sure if that person is going to be speaking.
Does Tracy M want to address the committee? If not, I appreciate everybody's time for this public hearing. I will say that there's not too much that has been good that came out of the pandemic, but one of the things that has been helpful is that we are now able to have this type of platform where we have recorded this testimony, and I'm going to ask our legal staff to make sure that a link to this testimony is sent to all of the judges of the Superior Court. We had 7 participants testify, 3 in favor and 4 opposed to this rule change. I thought a lot of very helpful ground was covered, and it's not overly burdensome for all of the judges to have that information. So I will ask that a link to this be sent along with the other materials for the annual meeting of the Superior Court. Having said that, we will draw the public hearing to a close. And unless any members of the committee need to take a break, we can move right into our regular meeting for today. Do any of the members of the committee need to a break? If not, all right. I want to make sure we have both our regular meeting agenda and a supplemental agenda. Is that correct, Attorney Del Campo?
Yes, sir.
Okay. So the first item on our agenda is the approval of the minutes from March 2021 meeting of the Rules Committee of the Superior Court. By the way, you're obviously more than welcome to stay on, but I would appreciate it if our guests would turn off their camera so that members of the committee can turn on their cameras and we can hopefully see all of the members of the committee. So the first item is the approval of the minutes. Is there a motion to approve?
Judge Bella, so moved.
Is there a second?
Cobb, second.
Moved and seconded. All in favor? Any changes to the minutes? If not, all in favor say aye.
Aye.
Opposed say no. That passes unanimously. The next item is 2021-009, a notice pursuant to section 1-9C of orders by Judge Abrams and Judge Conway, removing the suspension of requirements and deadlines in certain practice book sections related to non-criminal matters. Attorney Del Campo?
Yes, Your Honor, that is...
Oh, there you go. Okay. I was waiting for your camera.
Okay, sorry. That you've had a couple of these. 1-9C allows the chief administrative judge in consultation with the applicable presiding judges and with the approval of the chief court administrator to remove or modify time limitations and that were suspended in this time of pandemic. There were several rules that were suspended. These orders by Judges Abrams and Conway removed the suspensions for several non-criminal matters. Under 1-9C, there needs to be a report to the Rules Committee of that modification or removal of the suspension in order so that you can decide whether or not you want to, on a prospective basis, only reject such adjustment. You've had 2 or 3 of these over the last several months, and this is that report to you. If you do not reject the orders, then any adjustments or suspensions made shall be effective until further notice. What the removal of these suspensions does is basically put the rules back in place as they were before the pandemic.
So I just want to be clear, taking no action is approval of the removal of the changes, correct?
Yes, Your Honor, correct.
I think I may have used a double negative in there. Are there any questions from members of the committee? If there's, does anybody want to take any action or just let the changes go into effect? We'll take no action. Thank you. Next is 2021-012, proposal to further revise section 26-1 to remove additional references to families with service needs filings to comport with Public Act 19-187. Attorney Del Campo.
Yes, Your Honor. This was a proposal submitted by Judge Conway. You did consider it back in December, I believe. What was noticed when we put the public hearing materials together was that there were a couple of sections at the end of section, a couple of provisions at the end of section 26-1, which were not changed. The intent of the proposal and the recommendation of the Rules Committee was in December to remove all reference to family with service needs. We did point out to Judge Conway that there was a couple of later sections in 26-1 that had that language in it. I have viewed this as a technical amendment, but wanted to bring it to Judge Conway and the committee. So if you agree with those couple extra additional amendments, those will go forward to the judges as well.
Thank you. I did consider them to be pretty technical, but I appreciate you bringing them to the attention of the committee. Is there a motion to approve those further revisions as were distributed?
So moved, Judge Bellis.
Is there a second?
Second, Judge Hernandez, Bridgeport.
Thank you. Is there any discussion? All in favor, say aye.
Aye. Aye.
Aye.
Aye.
Opposed, say no. That passes unanimously. If I understand this correctly, Attorney Del Campo, the supplemental agenda is really because we received several additional comments on Rule 8.4. Is that correct?
Yes, Your Honor. Multiple on 8.4. There was one by the Office of the Chief Public Defender on 1.8.
Right. Okay. We don't have to take any action on that, but did any members of the committee have any questions about those supplemental materials? Okay. If not, is there anything else on our agenda, Attorney Del Campo?
Yes, Your Honor. There was a revision to the original agenda, which included the proposed schedule of meetings for 2021-2022 of the Rules Committee. That you normally take up at this point such that we can start the meetings in September.
With all of the emails that were going around, I misplaced that item, so I apologize. Do all of the members of the committee have that proposed schedule of the meetings? Doesn't mean that we can't change it depending on circumstances, but we like to set it aside so people can try to block out the time in their calendars. Is there any discussion? All right. If not, do we actually vote on that, Attorney Del Campo?
Yes, please.
Then I will accept a motion to approve that schedule of meetings.
So moved, Judge Bellis.
Is there a second?
Second, Judge Hernandez.
Thank you. Any discussion? All in favor, say aye.
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 Opposed, say no. That passes unanimously. Anything else I missed, Attorney Del Campo?
No, no, you didn't miss. Just one comment by me to indicate that all of the materials with the changes that you made today will go to the judges for their annual meeting. Because of the pandemic year, because there were so many emergency rules that were enacted by the Rules Committee and adopted by the judges, some of which had sunset provisions. There may be some that go through this committee and that have come to public hearing now, but which will expire if the declared emergencies expired. So they will probably not make it back to the judges for the annual meeting. So we just have to figure out when the declared emergencies will ultimately end and what remains standing after that point, if that's acceptable.
Thank you. Is there anything further from any members of the committee? If not, I just want to, again, as I did at our last meeting, thank Attorney Del Campo and his great team for all of their hard work. This has been a particularly challenging year, not only for the members of this committee, but doubly so for those staff people who support this committee. And we certainly appreciate everything you've done to make this as seamless as possible. So thank you very much. With that, I will accept a motion to adjourn.
So moved. Judge
Is there a
Bellis.
second?
Second, Judge Hernandez.
It's been moved and seconded. All in favor, say aye.
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 Opposed, say no. We'll stand adjourned. Thanks, everybody, for your participation.